Good day, sir. Good day, everyone. My name is Angelica Afable, and I'm from Group 8. And my topic is dispute resolution to different forms of labor strikes. Dispute resolution is one of the functions of a sound political system. It refers to a number of processes used to resolve a dispute between parties. A dispute is a disagreement, argument, or controversy that gives rise to a legal proceeding such as arbitration, mediation, or a lawsuit. There are many types of dispute. Examples include family, neighborhood, employment, business, housing, personal injury, securities, consumer, and environmental disputes. And these are the types of dispute resolution. Number 1. Litigation. Litigation refers to the process of resolving disputes by filing or answering a complaint through the public court system. It is the most familiar type of dispute resolution. Civil litigation typically involves a defendant facing off against a plaintiff before either a judge or a judge and jury. Number 2. Alternative dispute resolution. This refers to the procedure for settling disputes without litigation, such as arbitration, mediation, or negotiation. Alternative dispute resolution system in the Philippines. According to the Alternative Dispute Resolution Act of 2004, alternative dispute resolution system refers to any process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an offer of a government agency as defined in this act, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination. And these are the types of alternative dispute resolution. 1. Arbitration. It is a voluntary dispute resolution process in which one or more arbitration appointed in accordance with the agreement of the parties or rule promulgated pursuant to Alternative Dispute Resolution Act of 2004 resolve a dispute by rendering an reward. RA 9285 2004 Section 3. Arbitrator is the person appointed to render an award alone or with others in a dispute that is the subject of an arbitration agreement. Award is any partial or final decision by an arbitrator in resolving the issue in a controversy. Number 2, mediation. Mediation. It is a voluntary process in which a mediator selected by the disputing parties facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. Mediator is a person who conducts mediation. Information obtained through mediation is privileged and confidential. A party, a mediator, or a non-party participant may refuse to disclose and may prevent any other person from disclosing a mediation communication. Number 3, conciliation, also referred to as negotiation. It is the least formal type of ADR. The goal of negotiation is to help parties to come to a consensus on their own. Parties can involve a neutral third party into their negotiation to help facilitate an agreement. Labor dispute. Labor dispute refers to any controversy or matter concerning terms and condition of employment or the association or representation of persons in negotiating, fixing, maintaining, changing, or arranging the terms and condition of employment, regardless of whether the disputant stands in the proximate relation of employer and employee. Employees have the right to self-organization and to form, join, or assist labor organizations of their own choosing for the purpose of collective bargaining through representatives of their own choosing to engage in concerted activities for the purpose of collective bargaining and other mutual aid or protection. Strikes, picketing, and lockouts. Labor dispute can lead to labor strikes and or lockouts. Strikes refers to any temporary stoppage or work by the concerted action of the employees as a result of an industrial or labor dispute, whereas a lockout is a temporary refusal of an employer to furnish work as a result of an industrial or labor dispute. Two grounds of the valid exercise of the right to strike or lockout, namely Chan Robles Virtual Law Library 2008. Unfair labor parties and Robles Virtual Library and bargaining deadlock. Failure to agree the terms and conditions of the collective bargaining agreement between the management and the union while on strike, employees can conduct a picket. While on strike, employees can conduct a picket. Peacefully picketing is the right of workers during strikes consisting of the marching to and from before the premises of an establishment involved in a labor dispute, generally accompanied by the carrying and display of signs, placards, or banners with statement relating to the dispute. These are the different forms of labor strikes. Temporary stoppage of work due to labor dispute has different forms. They are 1. Legal strike. Legal strike, one called for a valid purpose and conducted through means allowed by law. Number 2. Illegal strike. One stage for a purpose not recognized by law, or if for valid purpose conducted through means not sanctioned by law. Number 3. Economic strike. One stage by workers to force wage or other economic concession from the employer which he is not required by law to grant. Number 4. Unfair labor practice. ULP strike. One called to protest against the employer's acts of unfair practice enumerate in Article 248 of the Labor Code as amended, including gross violation of the collective bargaining agreement and union busting. Number 5. Slow down strike. One stage without the workers quitting their work, but by merely slackening or by reducing their normal work output. Number 6. Wildcat strike. Undeclared and staged without failing the required notice of strike and without the majority approval of the recognized bargaining agent. Number 7. Sit-down strike. One where the workers stop working but do not leave their place of work. Legal requirements in conducting strikes and lockouts. A strike or lockout notice shall be filed with the Labor Department at least 15 days if the issue raised are unfair labor practice, or at least 30 days if he issues involves bargaining deadlock. The strike or lockout shall be supported by a majority vote of the members of the union or of the members of the board or directors of corporations or associations or partnership obtained by secret ballot in the meeting called for the purpose, and strike or lockout votes shall be reported to the Labor Department at least 7 days before the intended strike or lockouts. That will be all for my topic. Thank you for listening, sir and classmates.